G'day friends and welcome to Shed Gospel. It's Nigel Woolley. Great to join with you today on this Wednesday morning and to talk about some of God's Word and also talk about a few things I've found in High Court decisions. So just endeavouring to do another educational video that's going to encourage you. But firstly, there's a scripture I want to read this morning that is really good. It's talking about being a man under authority, setting yourself under authority, and that this was a centurion that came to Jesus, and he said his servant was sick, and he said, "Lord Jesus, speak the word only, and my servant shall be healed." But then he spoke the principle, and it's really good when you have a look at what this man said, this Roman centurion said, and it actually relates to issues that we find today. And obviously I've been going through things about the crown and assembling ourselves lawfully under the crown, And so this guy, this centurion had a servant that was sick. But he said to Jesus, he said, "Lord, trouble not yourself, for I am not worthy that you should enter under my roof. Wherefore neither thought I myself worthy to come unto you, but say in a word, and my servant shall be healed. For I also am a man set under authority, having soldiers under me. And I say unto one, Go, and he goes, and to another, Come, and he comes, and to my servant, Do this, and he doeth it." When Jesus heard these things, he marvelled at him, and turned him about, and said unto the people that followed him, "I say unto you, I have not found so great faith, not in Israel." But this man, this centurion, was to be commended, but he spoke about a principle that when you're set under authority, then you have authority. That's the principle, isn't it? So if you can prove, or if you can set yourself under authority, and that's demonstrated that you're under authority, then you also have, by flow, authority in the areas that you've been given. So, when you're under orders, when you've been given orders to do, and you're under and obeying those orders, then you can give orders in order to get your orders done, So I thought that was really good, and certainly a biblical principle in putting yourself under authority to have authority. So the Bible talks about praying for those who are in authority. It says pray for all those who are in authority. But that's the thing, is determining whether we have people still in authority or whether they're actually in a usurped position and there is no authority, So in terms of that, this is why I'm doing a video today. I mean, there's so much to do with all this stuff. There's so much to get into. Really do your own research. I can only just kind of give you some tips and things that I'm finding, but that might be interesting to you. But today I have some stuff from our Commonwealth Constitution, but in terms of the acts of the Act of Parliament that created our Commonwealth Constitution was because of the will of the people. So in determining all those who are in authority today and who's actually in charge in a lawful way, have they done what the fundamental law says in this country? And if they're disobeying the fundamental law, which is our Commonwealth Constitution, they actually have no authority. They've not assembled themselves properly under the lawful authority that was given to them. But in terms of the lawful authority given to them to do their job, it's the will of the people that came together to devise the Commonwealth Constitution. And because the will of the people could not enact it, and because we were still at that stage a British colony, we're a collection of British colonies, and we had British subjects here, So essentially it was the will of the British subjects that lived here in Australia that went back to the UK Parliament, Queen Victoria, and said, "Please, we've already agreed, we've had these referendums, we want to do this. Can you please enact this for us?" And so what that did was creating the Commonwealth Constitution, but the Commonwealth of Australia, it's the collection of the people. It's the federal polity, they call it, as a federated community of people. So all authority comes obviously under that as the fundamental law of this country. It changed the colonies into states, and it turned the whole of Australia into one federated colony. So that's the way it is. That's the status of us right now. It's one federated colony. Indissoluble federal commonwealth, but we're known as the Commonwealth of Australia. So already here today, I've got some stuff that's interesting for you. But the Australia, ready here from New South Wales versus the Commonwealth 1975. It's a court case. Chief Justice Barwick said on paragraph 49, the Australian Constitution was an act of the Imperial Parliament. Covering Clause 9 gave effect to the agreement of the people of the Australian colonies to unite in one indissoluble union. It conformed to the wishes of those people by enacting a federal constitution. A new colonial polity was brought into existence. There was no statement of the territory of the new entity, the Commonwealth of Australia, but it is evident that it was the sum of the colonial territory which had been placed under government by the imperial authorities, with a territorial boundary ending at low water mark. On the passage of the Imperial Act, those colonies ceased to be such and became states, forming part of the new Commonwealth. As states, they owe their existence to the Constitution, which by sections 106 and 107 provides their constitutions and powers referentially to the constitutions and powers which the former colonies enjoyed, including the power of alteration of those constitutions. Those constitutions and powers were to continue by virtue of the Constitution of the Commonwealth. But those constitutions and the powers of the states were subjected to the Australian Constitution. They were not the same as they had been before Federation. The constitutions were continued subject to this Constitution. The federal nature of the Constitution is seen in the distribution of constitutional power between the new Commonwealth and its constituent states, specific legislative topics being assigned to the Commonwealth and the residue to the states. Paramountcy being given to the Commonwealth laws where inconsistency with state laws exist. That residue is only discoverable when the full extent of Commonwealth power has been elucidated. So, what you can glean from that one, from that court case, it's only paragraph 49, it's very good. But it gave the context that, it was the people, the union of the people. The whole thing, the Commonwealth Constitution is about the union of the people that resided in the colonies. But in order to have this happen, to turn the whole lot into one mass, it had to be a changing of status of colonies, but they became states. It wasn't just a change in name, it was a change in function and all sorts of things. But what we have is that the union of the people was what drove all this, drove the change, the union of the people. It wasn't the politics of the colonies that drove this. It was the people. And once you get that in your head, it's the people. It's all about the people. Then you can begin to start seeing things from the proper perspective. I think the High Court's made some blunders in the way that they've dealt with some cases. And the reason I can say that is because when you read the cases, the judges will actually disagree with the reasoning of some of the judges before them. So if they disagree with each other on things, then even though the High Court's been given the powers of interpretation of our Commonwealth Constitution, different interpretations may conflict, and depending on what the view of the judge was. So we have to be able to get a fairly broad spread of court cases to get a true, accurate depiction of the way it is. Even though once you start reading these proper cases, you can begin to see the Commonwealth Constitution in its own light. That it is the union of the people. It's people-centric. This whole thing is people-centric. And so the colonies that have now turned into states, they had to follow suit with this whole thing. And because it was the will of the people that lived in them, that essentially, unless the Commonwealth Constitution had provided a place for these colonial parliaments to exist and turn into states, and their futures were in doubt. You know, no longer was it the way it was. No longer is it now the way it was. But the mindset of the people at that time did carry on through Federation. And so that became a lot of heated discussions between the federal parliament and the state parliament, especially New South Wales, there was many people in New South Wales Parliament who did not like Federation. So, you know, rebellion does happen amongst these parliaments. But eventually now, you know, after many, many years, they've kind of had to succumb to the reality that the people wanted this and this is the way it is and you can't change it and you can't change the Commonwealth Constitution unless by the will of the people. You know, the whole thing. So, in another court case, Victoria versus the Commonwealth, 1971, HCA 16, paragraph 5. The Commonwealth Constitution was enacted at Westminster in 1900 as a product of the assent and agreement of the peoples of the Australian colonies. It was sought by Australians, not imposed upon them. That's really good to remember too, that it wasn't the idea of the British that came up with this. It was us. It was the people of this Commonwealth here, the Australians. It was sought by Australians, not imposed upon them. The Constitution Act itself was carefully worded so as not to be coercive. Section 3 provided that Western Australia should not become part of the new Commonwealth unless Her Majesty was satisfied that the people of that colony had agreed thereto. So Queen Victoria was being very careful with the way that she dealt with our Commonwealth Constitution, even in its draft form, because she considered that maybe the people of Western Australia didn't want to be part of this Commonwealth. And so she was not excluding them, but she just said, look, wait till I hear from you guys to include you, and wait to hear from the people who live in Western Australia as to what they want. Don't you think this is good? Don't you think this is refreshing to hear that it is people? It was people that changed Queen Victoria's mind. Even though she was kindly dispositioned, she wanted to actually do this thing anyway, but she didn't want to prescribe the Commonwealth of Australia across the whole lot unless the people had agreed in a referendum that they wanted that. And so that did actually happen. That happened around October, I think it was. Early weeks of October, September 1900. She got word of that. As an agreement of peoples, British subjects in British colonies and the enactment thereafter by the sovereign legislature of the British Empire of a law to give effect to their wishes, the Australian Federation can be described as springing from an agreement or compact. But agreement became merged in law. The Constitution is not an ordinary statute. It is a fundamental law. So, this is here. This is decisions of the High Court, binding upon all. Okay, the Commonwealth Constitution is binding upon all. The laws of the federal Parliament are also binding upon all. So, but the High Court have been given the powers of interpretation with our Constitution. But, you know, as I said, you know, sometimes their ideas conflict. But it's good to read the good ones because it gives you the proper context. You can see who's not quite right when you read enough of this stuff. And it is the will of the people, of course. So the High Court are there essentially to preserve the Commonwealth Constitution and to preserve this polity of people. So, it's very good. When you start looking at what the states have done and the way that they've replaced their constitutions, you can see that they're actually in disobedience to our Commonwealth Constitution. Totally. Here we go. McGuinty versus Western Australia. HCA 48. McGuinty was the Attorney General of Western Australia, I think he was. Is he? I don't know. He's Attorney General, I think he was, McGuinty. So I don't know where he was from. I think he was from Western Australia, but I could be wrong. McGuinty versus Western Australia. This is HCA 48, paragraphs 17 to 19. Section 106 of the Commonwealth Constitution reads, the Constitution of each state of the Commonwealth shall, subject to this Constitution, continue as at the establishment of the Commonwealth. or is at the admission or establishment of the state, as the case may be, until altered in accordance with the constitution of the state. So that section 106, I'll give you my paraphrase of it, which fits in with High Court decisions, is that it's a double-edged sword. The states were allowed to have their constitution. They were guaranteed that their constitution was going to continue. But also it's a double-edged sword because they were to continue their constitutions. And that they were given the powers of alteration of that constitution, of that one, not to replace it, not to, change the deal mid-deal, but to have the powers of alteration. That's okay. But not to remove it. And that's what they've been doing. They've taken their constitutions out, put new ones in, unlawfully. This section has a dual operation. Its first operation is to prescribe what the new elements of the federal polity, the states, shall be. When the people of the Australian colonies were united in the Commonwealth of Australia by the proclamation made pursuant to Covering Clause 3, those colonies became original states of the Commonwealth by operation of Covering Clause 6. The colonies, the old constitutional entities, acquired a new constitutional status. They became states, as the text of sections 107 and 108 shows, deriving their existence as states from the Commonwealth Constitution. Secondly, section 106 conferred on the respective states substantially the constitutions of the antecedent colonies. The same constitutions as had been conferred on the colonies prior to January 1901 were continued as the constitutions of the respective states thereafter, subject to such modifications as were effected by the Commonwealth of Australia Constitution Act and the Constitution of the Commonwealth. As Barwick, Chief Justice, said in New South Wales versus the Commonwealth, on the passage of the Imperial Act, those colonies ceased to be such and became states, forming part of the new Commonwealth. As states, they owe their existence to the Constitution, which by sections 106 and 107 provides their constitutions and powers referentially to the constitutions and powers which the former colonies enjoyed, including the power of alteration of those constitutions. Those constitutions and powers were to continue by virtue of the Constitution of the Commonwealth. Although the states owe their existence to the Commonwealth Constitution, and although their respective constitutions in 1901 were conferred by operation of Section 106 of the Commonwealth Constitution, the powers vested in the respective state legislatures were subject not only to the other provisions of the Constitution, but also to the limitations which had been imposed on the powers of the antecedent colonial legislatures. So the limitation of a power of the colonies, do you think the colonies had the powers to replace their constitutions before? Do you think that these colonies had the powers to write their own constitution, being constituted on an act of the UK Parliament up until that time? Do you think that they had the powers, the inherent powers to replace their own constitution? No. So why did they get the same powers after Federation? They had the same powers after Federation, but those powers don't extend to replacing the state constitution. It doesn't get greater just because they're a state in the Commonwealth. See? So they're subject to impose limitations as well. The Australian colonies did not retain their colonial status for the purposes of the constitutional law of the Commonwealth, but their general legislative and constituent powers then remained amenable to affection by laws enacted by the United Kingdom Parliament. That amenability to affection by imperial legislation was removed only by the enactment of the Australia Act, 1986. In 1901, Section 107 of the Constitution confirmed what Section 106 might have itself have provided, namely that such power as a state parliament possessed to alter its own constitution, pursuant to the matter and form provisions of its constitution, and to alter those matter and form provisions themselves, remained. Thus, the manner and form provisions of the state constitutions are retained as they were on 1st of January 1901, or as they have been altered subsequently in accordance with any relevant manner and form provisions in force at the time of the alteration. It follows that the constitution of a state at any time must be ascertained by reference to its constitution as at federation, the overriding effect of the provisions of the Commonwealth of Australia Constitution Act and the Constitution of the Commonwealth, and the modifications of the state constitution that have been made either by imperial legislation or state legislation, provided in the case of state legislation it has been made in accordance with any relevant manner and form provisions of the particular state constitution and the Australia Act. So, really, does a state have power to replace the constitution that it had at federation, that brought it into the Commonwealth, that turned into a state constitution? No. The powers conferred on the Parliament come from the constitution of the colony. The constitution of the colony sets out that the Parliament shall have powers to create laws for the peace, order and good government, But to replace that enactment from the UK Parliament to an enactment of its own self, it's now outside of the deal. It's done something that was extra to the deal that we did not agree to, we did not consent to, we were not involved with in referendum. They're now outside of the deal. And as I said on the video yesterday, all of the UK acts mesh. There's a meshing of the UK acts because you've got the imperial acts that made the state colonies, made the colonies. You got the imperial acts that set things up with them to begin with. And you also have the Imperial Act, which is our Commonwealth Constitution. All those things mesh together as at federation, and now form our Australian Commonwealth. But for a state to go and replace its constitution is outside of the deal. So they don't have powers to make laws for you. That's it. That's what they've done. And they're trying to justify it in many ways. But it's the will of the people. It was the will of the people that agreed, well, look, we want their state constitutions to continue, and the colonial constitution to continue. So it was the will of the people in that regard as well. So looking at it from the will of the people, if you'd said, well, look, I want our colonial constitutions to continue as state constitutions, and that's your deal with them, they go and replace the constitution on you, and you haven't agreed to it, you haven't even known about it, it wasn't put under your nose, wasn't put to referendum, you didn't involve any people of the Commonwealth. Therefore, they're outside of the deal. So that's what's happened. And we need to get that in our heads, that our states have betrayed us altogether. So, this is another court case called China Ocean Shipping Co. versus South Australia, 1979. The Commonwealth, paragraph 21, the Commonwealth, by the grant of the Constitution, in my opinion, quite clearly became a colony. Indeed, it might well have been concluded that it became the colony. The former colonies, whose people were united in the indissoluble Commonwealth, could have been considered no longer to be colonies, having become constituent states of the new Commonwealth, albeit with constitutional powers identical in content with those formerly existing, but now deriving, but subject to its terms, from Section 106 of the Constitution. But though this view has not been taken, the new Commonwealth became itself another colony, self-governing, but lacking both political and constitutional independence. It's interesting, isn't it? You know, Australia, as such, is a big colony. Yeah. So, another case. Durham Holdings Proprietary Limited versus the State of New South Wales. And this is by Justice Michael Kirby. 2001. Durham Holdings versus the State of New South Wales, 2001, HCA 7. Justice Michael Kirby said in paragraph 53, before modern times, English legal history contained many examples of statutes, enforced by the courts, by which the Parliament and Westminster authorised the acquisition of property without compensation. The statutes by which the Crown appropriated the lands of the monasteries in England provided an early illustration. Of direct relevance to Australia are the Imperial Acts, which necessarily deprived the indigenous peoples of Australia of any rights that they might have enjoyed in land acquired for the purposes of British settlement. If the validity of such legislation has not hitherto been questioned, some point of distinction connected with a different status belonging to the New South Wales Parliament would have to be found to justify a legal approach different from the acceptance accorded to analogous laws of the Westminster Parliament. That's interesting. Justice Michael Kirby, he's saying that, hang on, New South Wales Parliament's got a different status. It's a bit of a backhanded swing. New South Wales Parliament's got a different status than what it had. He knows that New South Wales Parliament's sitting on an act of its own self. It's unlawful. But, you know, the court case he was dealing with was not there to destroy New South Wales Parliament. So he just sort of put a few little backhanded swings in there, which is interesting. So, and it was in this court case, Durham Holdings versus the State of New South Wales, that I said yesterday that Justice Michael Kirby said that it's sort of been unexplored, the reality that the Commonwealth Constitution is the will of the Australian people. And that needs to be taken as the view for dealing with court cases, certainly with regarding the Commonwealth Constitution. So, you know, as far as where we are as people of the Commonwealth, I just really feel with a lot of these videos, they're probably striking a bit of a chord with people because it puts value back on the people. Back on the people of the Commonwealth, that you were essentially one of the ones that said you wanted your will to create this new community that was transcended beyond the colonies that it once had, Australia, and to create this new federated community. But this is the thing, that it's up to us now. It's up to the people to keep reinforcing that our Commonwealth Constitution is our will. You know, you may not agree necessarily. I don't think there's anything in there to disagree with myself. I think it's very good. It's only just basic framework. But because our states and our Commonwealth aren't obeying it, they're not doing it, we have then the right to say, you're not even obeying the one thing we gave you. You're not obeying the very thing that created you. So it's a very powerful argument. In standing lawfully and taking the lawful oath, you know, and standing up for our Commonwealth Constitution is probably one of the most noble things that you can do as an Australian. And I think this is a foreign concept to us. We see it happening in America. They go on about their Constitution a whole lot. But for us, we have our own future to get into. But the reality is the framers already saw a future for our country that was not, Australia is not America. Australia is not Canada, of course, or England. You know, Australia is us. But in terms of our future here and the purposes for our future and a good country, then we have to realise that the Commonwealth Constitution is our social contract. You know, they can't do anything to us except it goes through that Constitution first, because the Constitution created them. You know, even the states, it turned them into states. So, you know, just in a sense of morale for us, in a sense of purpose and value, and putting value back on people, our Commonwealth Constitution has already got the view that the people are supreme. You know, there's nothing that they can do out there, even through collusion with the news media, through acts of parliament. There's nothing that they can do that will overturn that relationship unless we let it. The Commonwealth Constitution doesn't let it. And it's the fundamental law in this country. But the problem is that if we allow it to be overtaking, if we allow their garbage to overtake our mind so we don't stand up for our Commonwealth Constitution, which puts us as supreme. If we don't stand up for that and we just let their lies and garbage come in and take us over, then we won't enjoy the freedoms that our framers had devised for us. You know? So a lot of this stuff is so foundational, so basic, but we've missed this. They don't teach this stuff in school. They don't teach this stuff, I don't think, in law school. I've never been to law school, of course, but I think they gloss over a lot of these realities because the powers that be right now don't like the idea that we are supreme. They never have. From the moment that our Commonwealth Constitution came into force, there was forces against it. There was forces against the reality that the people are supreme. And it's kind of like these people that hated that reality because they were so used to being redcoats, you know, the redcoats, bastards, flogging good people, you know, abusing people. Because that's been their attitude, and that's been such an undercurrent and a flavour within Australia from its history, then a lot of those things are just incongruous with our Commonwealth Constitution. They are. They're incongruous with the values that it puts on us, that the framers already knew, that the people had agreed to. But, you know, we are a federated community, and all things are derived from the will of the people now. So if Daniel Andrews down there in Victoria or ScoMo or any one of these other people are pushing beyond their constitutional limitations to try and force things upon you, to try and overturn the constitutional relationship that you have with them, and on that basis they are acting ultra vires, which is beyond their powers, and their laws, acts and statutes, whatever they create there, directives, are beyond the powers, because it's beyond the powers that was given to them at Federation as the will of the people. See? So just want to leave this video with you today and to encourage you, but there's plenty of these High Court decisions that I've been reading. You know, New South Wales versus the Commonwealth 1975, that's a good one. Paragraph 49. Victoria versus the Commonwealth 1971, HCA 16. Paragraph 5. Residual ASCO Group Limited versus Spalvers 2000, HCA 33, paragraphs 58. That's good too. And there's McGinty versus Western Australia 1996, HCA 48, paragraph 17 to 19. That's a good one. China Ocean Shipping Co. versus South Australia, 1979. Paragraph 21. Durham Holdings Proprietary Limited versus the State of New South Wales, 2001, HCA 7. Paragraphs 53, 66, 73, and it goes on. So that's a good one as well. But they're all good stuff to try and show you that the High Court have got some good decisions that they've made that are on our side, and to bring out the truth that it was the people, the will of the people, that created this whole federated community, and it was done by an act of Queen Victoria. They all must obey it, they must respect that, and we have ultimately the power, but we've delegated powers as the will of the people to them to do jobs for us. So God bless you, friends. Take it easy, have a lovely day, and make sure you get outside and enjoy the sunshine while it lasts, and I'll catch up with you later. See ya. Bye.